Hey, what's up, guys? I know with the trial looming next year, summer 2025, but I just have one question, guys. Why are we in the true crime community so divided when it comes to the guilt or the innocence of Bryan Kohberger? I mean, we all want the same thing. We want justice for the victims. Justice for Xana, Maddie, Kaylee, and Ethan. But we also want justice for Bryan because a wide variety of us feel that he's a patsy in this case. But I just don't understand how we're so divided and labeling each other guilters and pro burgers. We want the same thing. We want justice. Whether he be guilty or innocent. We want justice. It doesn't matter where we stand, where we're in Bryan's corner or in the corner of the victims' families. We all want the same thing. Just like when it comes to the change of venue. Comes now the state of Idaho by and through the Latah County prosecuting attorney and objects to the defendant's motion to change venue. The defendant has filed a motion to change venue, requesting that the trial in this matter be moved from Latah County, where the offense took place, to Ada County, some 300 miles away. To support his motion, he conducted a survey of prospective jurors in Latah County, Ada County, Canyon County, and Bannock County, but far from demonstrating that a Latah County jury pool has been uniquely subjected to an utterly corrupted environment, as defendant argues in his brief. The data shows that pervasive and wide-ranging coverage of this case throughout the entire state of Idaho has led to high case recognition among survey respondents across all four surveyed counties. The court should decline defendant's invitation to parse and split hairs over an incomplete data set to reverse engineer a transfer to Ada County, which, according to defendant's own experts, has received the second highest amount of media coverage in the state, and whereas a statistically greater number, albeit slight, of the survey respondents familiar with the case believe defendant is guilty. The court should deny defendant's motion and instead focus on crafting remedial measures to ensure that a fair and impartial jury can be seated in Latah County. Well, see, the only reason why they don't want the case moved to Ada County is because there could be a possibility that Ada may find him guilty, but not sentence him to death. Now, if you look at the Lori Vallow Daybell case and the Chad Daybell case, Lori Vallow got life in prison without the possibility of parole. Chad Daybell got the death penalty. So are they wanting to make sure that he gets the death penalty there in Latah? Because they think that if they move it to Boise, he'll get life without parole. And mind you, If he gets life without parole, that doesn't mean he's going to be sitting in an Idaho prison. He can be moved to another state and serve his time out there. And since he's from Pennsylvania and he gets hit with life without parole, he could always put in a request to be moved to a Pennsylvania prison and serve his time out there. Now, if it's the death penalty, then yes, he's staying in Idaho. But if it's life without parole, there's pretty much good odds he won't be spending all of his time in Idaho. They could move him to Pennsylvania or to Texas or to Arizona or Utah, wherever. And even with the death penalty case, in Idaho, it's 27 years before you're actually executed. 27 years. So the victim's family is going to be dealing with this if he gets convicted for the next 27 years. If he is sentenced to death, it would be 27 years that the Gonzaleses and the Mogans and the Chapins and the Laramies and the Kernodles will have to deal with this for the next 27 years until he's put to death. But personally, I don't believe that he's guilty at all. We haven't seen any of the evidence because Bill Thompson keeps sealing the evidence up. Although the government generally may prosecute an offense in the county where it occurred, a court may change venue to limited circumstances. First, a court must change venue to another county if the court is satisfied that a fair and impartial trial cannot be had in the county where the case is pending. Change of venue on both bases for the following reasons. The defendant has failed to show that either of these circumstances applies. Well, he's not going to get a fair trial in Latah because a lot of us have seen Bill Thompson throw his temper tantrums, especially when they did the jury survey. He threw an absolute temper tantrum. Defendant has failed to establish that a fair and impartial trial cannot be held in Latah County. Defendant has argued that due to pervasive publicity in this case, a change of venue is appropriate. Defendant further claims that the atmosphere of Latah County has been utterly corrupted by media coverage it is undisputed that the defendant has a constitutional right to a fair trial with a fair jury and a panel of impartial, indifferent jurors. On a change of venue motion, it is defendant's burden to show reasonable likelihood that pretrial publicity will deprive him of a fair trial. Well, if you look at it, he's not going to get a fair trial in Latah because of the university, the U of I. The mayor, Bill Thompson, Kathy Mabbitt, they're all, alumni of the U of I. And even the judge, his wife is a tenured professor at the U of I. So that's a conflict of interest on the judge's part in the case. Now, will he be impartial? Possibly. Possibly. But will Bill Thompson be impartial? I don't think so. And especially, they had the crime scene torn down December of last year. So that, and the only way the jury can see the inside of the house now is through still photos and a 3D rendering. It was a huge mistake to tear down that house until after the trial. But it was Scott Green and the University of Idaho fighting hard to get that house torn down because, quote unquote, they wanted to start the healing process. Okay, that's understandable, but you could have did that after the trial. You could have had the house torn down after the trial, not before the trial. On a change of venue motion, it is a defendant's burden to show a reasonable likelihood that the pretrial publicity will deprive him of a fair trial. However, where pretrial publicity is at issue, a presumption of prejudice necessitating a change of venue applies only in the most extreme cases. The mere fact that the crimes reported by the media are gruesome or memorable does not render the publicity inflammatory to the extent of requiring a change of venue. The United States Supreme Court also explained that juror impartiality does not require ignorance. In determining whether pretrial publicity has risen to a level that justifies a change of venue, I think it has. The United States Supreme Court has also held that only in the most extreme cases is a defendant afforded a presumption of prejudice based on pretrial publicity. I.e., in a bank robbery, homicide, defendant afforded presumption of prejudice where his videotaped confession during a police interrogation was aired on local news 3 times and seen by thousands. Okay, I don't even think Bryan was interviewed, interrogated, or what. I don't think he was. Because if he was, we would have heard about it before the gag order was implemented. We would have heard about him being interviewed or questioned even before the gag order came down. During court hearing proceedings, judge allowed unmitigated camera access to the courtroom, including the filming of jurors' faces. Neither Radu nor ST apply here. Defendant in this case did not confess to the defendant in this case did not confess to the murders. Did not confess to the murders. Let alone on video broadcast to thousands, and it is the state's understanding that the court will not allow filming of jurors' faces at trial in this case. Defendant urges this court to find that Shepard v. Maxwell, another U.S. Supreme Court case, applies here. Defendant's memorandum in support of motion to change venue. But Shepard is wholly inapplicable to this case. In Shepherd, bedlam reigned at the courthouse during the trial, and newsmen took over, particularly the entire courtroom, hounding most of the participants at the trial. Within a few feet from the jury box and counsel table sat some 20 reporters staring at Shepherd and taking notes. This case has nowhere near the chaos present in Shepherd. As the Shepherd court explained, the carnival atmosphere at trial could easily have been avoided since the courtroom and courthouse premises are subject to control of the court. Here, the court has scrupulously avoided such an environment. The court entered a non-dissemination order early in the case. When the small press pool that was allowed in the courtroom failed to follow the court's instructions as to filming or photographing the defendant, the court disallowed any media filming, photographing, or audio recording of court proceedings. This court has repeatedly taken precautions to avoid the circus-like environment described in Shepherd, and thus Shepherd is easily distinguishable and a poor comparison to this matter. Bill Thompson is not wanting this case moved at all. He don't want to have to travel to Ada. He thinks he can get a clean jury pool there in Latah County. I don't think he can. I really don't. Because he was throwing an absolute tirade because of the jury survey questions that Edelman had set out. You had a woman call the sheriff's department because her son got a jury survey, and Bill Thompson stood up in a court hearing, said that Miss Taylor, could have possibly contaminated 400 people in the jury pool, and he was trying to accuse her of violating the non-dissemination order. Like, what's going on in the case? As the case law makes clear, the test is not knowledge of the case, but rather partiality. See Hayden and see State versus Hairston. Thus, the fact that Latah survey respondents have the highest percentage of knowledge about the case compared to other counties, it is far less significant that the fact the Latah County survey respondents had the least amount of overall prejudgment among the counties. And we all know that's not true because this case happened in Latah. The survey data provided by Dr. Edelman is inadequate to justify a change of venue. It is not reported how many individuals declined to take the survey, raising serious concerns about non-response bias. Wasn't it Bill Thompson said that 400 potential jurors had been poisoned by the survey? A glaring omission in the data provided by Dr. Edelman is the lack of any information about the number of individuals who were contacted but chose not to respond to the survey. This is important because non-participation bias can change the outcome of such a survey. What low response rate means for telephone surveys, Pew Research Center, available as of the authoring of the 2017 article promulgated by the Pew Research Center, telephone poll response rates stabilized at approximately 9% after years of decline. Well, the Pew Research Society article concludes that the low response rate does not necessarily lead to a conclusion of bias across all subject matters. Low response rate can skew results in specific areas. For example, individuals with high civic involvement are overrepresented in surveys, as the Pew article explains. Telephone polls greatly overstate civic engagement, probably because of non response bias, and has been established in previous work. The public who answer surveys are likely to be the same people that are involving in the community's public life. There are joiners such as phenomenon could easily play a role here. Where are the where at the very outset of the survey, respondents were told that they were being asked for opinions about an upcoming jury trial. I'm sorry, guys. Bill Thompson is fighting like heck to keep this trial in Latah County. Now, I know there's some of my subscribers and viewers that feel that he won't get a fair trial there in Latah County. And I feel the same way, guys. I do. I don't think he can get a fair trial in Latah. He might get a fair trial in Ada County, Boise, but we don't know that for sure. Like always, guys, like, comment, subscribe to my channel. Hit that bell notification for any new uploads. And I want you guys to have a good Wednesday night, Thursday morning. And this is TCC out.